We're going to get started with our next speaker. We've got Jessica Barry from the Legal Aid Society, who's going to be joining us via Zoom. She's going to be talking about their Simple Wills program and just a bit of general information about Legal Aid Society and wills in general. So thank you so much for joining us, Jessica.
Hi, thank you for having me. So again, my name is Jessica Barry. I'm a staff attorney at the Legal Aid Society of North here today to talk about a new program we're starting with the City of Albany and to give some general information about wills. So the Albany City Simple Wills program, as you may have guessed by the name, the program is supported by the City of Albany. To be eligible for a will through this program, you must be at least 60 years of age. You must reside in the City of Albany and own no more than one property. You will also have to meet financial guidelines and other program criteria. If you're interested in this program, please contact the Legal Aid Society at 518-462-6765. And please let us know how you heard about the program. And I believe there should be flyers there available about this program and a lot of other programs that Legal Aid offers. So a disclaimer before I get into the real information about wills. This presentation provides general information only based on laws applicable in New York State. This is not legal advice, and receiving this information or attending a presentation which includes this information does not make you a client of Legal Aid. The law may change after I give this presentation, so we still recommend that you consult with an attorney for legal advice specific to your situation. And now about, a little about wills. First, I want to dispel some myths about wills and then answer a few frequently asked questions. So, when I started practicing, I had some questions, frequently asked, and I'm not sure how these, myths got started. But one of the common ones is that estate taxes will take everything. However, the reality is that most estates, which is the property that is left behind after you pass away, the value of that property very rarely meets the threshold to, be worried about estate taxes. And, just to know how, far or how much value your estate would have for it to be an issue, currently the federal estate tax exclusion is 11.7 million per estate. And that's adjusted yearly for inflation. And the New York State estate tax is currently 5.93 million. So, and so it's unlikely that it would apply to your situation, but it's still good to know where the estate tax stands. The second myth that I've heard a lot is that without a will, the state will take all of your property. However, the reality is that is not true unless you have no close relatives. So there are, I refer to them as the default laws about what will happen to your property after you pass away. If you do not have a will, they're called the laws of intestate succession. So they will look at whether you have a spouse, children, parents, grandchildren. You would really, it's possible, but the law does go as far as like cousins and first cousins before the state would even have a claim to your estate. The third myth I've heard is that I don't have a lot of property, so I don't need a will. And that's not necessarily true. And whether you need a will depends on if the laws of intestate succession, reflect your wishes. So if you want something different than the default, then you really should consider having a will. So even if you don't have a lot of property, if you want it to go to specific people, or if you want to name a specific person as an executor to handle your estate, which the executor would be responsible for filing paperwork with a surrogate's court, finding your will, paying all the estate debts. They're going to have to deal with a lot of paperwork in order to transfer ownership from your estate to whoever you want to gift that property to. So, so it is helpful to have a will, and even if you don't have a lot of property, the surrogate's court has a simplified estate proceeding called small estate. And then I believe it's a $1 filing fee. So it can be helpful to have a will. And then the surrogate's court has a process to make small estates easier to handle. The fourth myth is that you have to give $1 to somebody in order for them not to contest your will. So for example, if there is somebody in your family that you don't want to receive any part of your estate, some people have told me they think that they should give them $1 so they get something, and they can't then bring a proceeding to say the will wasn't done properly because I didn't get my fair share. So the reality is that you can disinherit your children without issue, and the spouse is a little bit trickier. But the dollar bequest will not make a difference. In order to have an effective will, you need to show that you are aware of the persons that are near and dear to you. We call them the natural objects of your bounty. And so you'll want to, name those people that you're not including to get gifts in your estate, just to show that you are aware of who your family is, but you're not required to give them anything, not even $1. And another myth, that you have to leave your will with an attorney or a bank. And I think specifically, with the bank, it's the security deposit box. And we highly advise against storing your will in the security deposit box, although it is, very secure in there. The issue is that, your will names the executor, and the executor is going to be the one that has to present your will to the surrogate's court. But in order for an executor to have access to a security deposit box, they will need to be appointed by the court to do so. So you can see that it's a little catch-22 if your will is in the deposit box, where that's the document that the executor needs to get into that box. So we recommend that when you have a will, that you store it in a safe and accessible place. You gotta leave it where it can be found. It has to be safe, but you want your loved ones to know where to find it. And another good option is to leave it at the Albany County Surrogates Court. They do have will storage there. My understanding is that it's free of charge. When you take the will to be stored, they will give you a receipt. And then the receipt is what you're going to have to keep track of, because that is what the executor will need to present to the surrogates court in order to get your will and take further action on administering your estate. Now I'm going to get into some frequently asked questions and give you some answers for those. So how does a will become effective? Generally, a will must be in writing, and it must be signed at the end by the person making the will. In the law, we refer to them as the testator. It must be signed in the testator's name. It can also be signed in the testator's name by another person in his or her presence at his or her direction, if the testator is, for whatever reason, not able to sign the will, his or herself. That person that signs the will on the testator's behalf must include their name and their address. The will must be signed by the testator in the presence of witnesses, and the testator must acknowledge that this is their final will to the witnesses for that will to be effective. It's the signing ceremony. And those two witnesses must also sign their name and include their address, just to show that the documentation that they did witness that will signing and that it was done appropriately. And a little follow-up to the witnessing is that typically when we do a will, we also do a self-proving affidavit, which states how the witnesses watched the will signing. So that affidavit can be taken to the surrogate's court, and it can simplify the process for the surrogate's court. So that would be something that would help your loved ones. If you have a will, you want to make sure that that self-proving affidavit is also done, just to ensure that the probate process, the process with the surrogate's court, will go as smoothly as possible. And so I talked about witnesses. So who can witness a will? While the New York State law does not have particular requirements for who is required to witness a will, you should not, that person that witnesses your will signing should not be receiving a gift in your will. You want somebody that is disinterested. And I don't, you know, there are I'm not sure if anybody's heard of a codicil. That is a little, it's similar to a will, but it's not. The will would still be effective if you have a codicil. The codicil is a document which adds to, takes from, or alters a will. It does not totally revoke the will, though. In my general practice, I have not done one. You know, just something to be aware of if there's only a small change and you don't want to totally revoke your will. Another question is, can I write my will myself? And you can, you know, if you can consult with an attorney, that's certainly advisable. But if you want to write your will yourself, you can. If you do so in the above manner, or, and of course, there's other exceptions too. If you're a member of the armed forces or a mariner at sea. But of course, and I must, of course, I have bias, I am an attorney, but we do highly suggest that you have an attorney assist you to make sure that the language used in your will provides for your property to be distributed in the way in which you intend, and ensures that all issues are addressed in your will. Another question, what if my spouse left me out of his or her will? So as I previously mentioned, that can be a sticky situation here. And in New York State, a spouse may be entitled to choose to take a share of his or her deceased spouse's estate. This is called the right of election. So if you try to disinherit your spouse can then assert this right of election during the probate proceeding. The elective share, you know, the amount that the spouse would get depends, of course, according to the estate size. So the spousal share is generally equal to the greater of 50,000 or 1/3 of the net estate. Note that the value of the estate may include the value of certain gifts given within 1 year of the death and other assets. And this right of election of the surviving spouse must be asserted. You have to bring that claim in a timely manner. So if you know another reason for me to bring up, please consult with an attorney if you think that might apply to you. The next question is, my spouse passed away. Do I need to make a new will? And you know, for an answer to that question, you would need to look at the document itself. You don't necessarily have to make a new one. Your old will may have already made a provision for what is to happen if your spouse dies before you. So the real question is, you know, does that will reflect your wishes? If it does not currently reflect your wishes, or if provisions have not been made for the event of your spouse's death, you might then need a new will. I made a will in another state, but now I live in New York. Is my will still good? So the answer here is that a will disposing of personal property, such as jewelry, furniture, books, in New York State or elsewhere, or disposing of real property in New York that was made outside New York, can be admitted to probate in New York. It is valid according to either New York law or the place of the law, or the law of the place where it was made. or the law of the place where the testator lived when it was made, or the law of the place where the testator lived at the time of his or her death. So this is a complicated one. So it looks like there's many ways that it could be effective still, but like I keep saying, definitely consult with an attorney. What if I change my mind? Can my will be altered or revoked? That's the next question. Will or part of a will can be revoked or altered by making another will or a written document which clearly indicates an intention to revoke or alter the prior will. That new document must be signed and witnessed in the same way as a will, with the two witnesses, with the declaring that this is your last will, and of course with the recommended self-proving affidavit. A will can also be revoked if the testator, which again is the person that drafted and signed the will, so the will can be revoked if that person burns, tears, cuts, cancels, obliterates, mutilates, or otherwise destroys the will, or directs another person to do so in his or her presence with at least 2 additional people as witnesses. If I made a will, does that take care of my estate planning needs? Not necessarily. As discussed above, you may need additional planning to deal with estate tax issues or to plan for disabled members of your family. If somebody that you love and that you want to leave an inheritance to, if they are in a program where they use disability benefits and a cash windfall might affect their eligibility, there are trusts that would be able to still benefit that person and keep them eligible for those benefits. So again, we advise you to consult with an attorney for those specific needs.